In the criminal justice system, criminal defendants are deemed innocent until proven guilty. Some of the accused are acquitted and walk free. Some, after a mistrial or hung jury, are tried for a second or even a third time. Then there are those defendants who have such overwhelming evidence against them, they will take a plea offer or risk their very lives in court. Due to the overwhelming evidence, a judge or jury have no other choice but to declare them guilty as charged. This is Bethea'S Byte, and it's reloaded. And good Sunday evening, everybody. East Coast, West Coast, wherever you are in this great country of ours, welcome to this special edition of Bethea'S Byte, Guilty as Charged. I'm Ernest Bethea, the last outlaw. So good to have you along with me. And we are in for a ride tonight. In addition to some of the normal cases that I'm covering tonight, I am covering 6 that are either verdicts, sentencing, or in one case, a parole hearing. More on that in just a minute. But first, let's go on down the docket. We're going to start with a new case that is just getting going. This is the state of Ohio versus Jackson Blaving, the death at the door murder trial. The case breaks down like this. A young man is pleaded guilty to the murder of a 71-year-old grandmother who was fatally shot in the front hallway of her home. Jackson Blaving, age 22, was indicted on 14 charges, including aggravated murder and felonious assault in the death of Connie Vang on March 14th. The day before his trial began, Blaving accepted responsibility. Well, this is where we should have started in the first place. Police responded to a 911 call to find the victim dead from a gunshot wound to her head. The Ohio Bureau of Criminal Investigation later joined the case. Blaving is also facing charges related to an attempted robbery days after Vang's death on March 17th. Police said Blaving tried to rob a former high school classmate's home by hiding behind a porch and pointing a gun at the victim when the door was opened. The incident, captured on a Ring doorbell camera, led to Blaving's identification. After the attempted robbery, Blaving fled the scene and discarded the firearm, police said. He was arrested later that evening at his home in German Township by agents from the Clark County Sheriff's Office and BCI. Several items of evidence had been recovered during the arrest. After his arrest, Blaving remained in custody at Greene County Jail on a $1 million bond. Judge Mike Buckwalter sentenced Blaving to an agreed plea deal of life in prison with the possibility of parole after 30 years. The maximum sentence Blaving faced was life in prison without parole. So, ladies and gentlemen, basically what we have here is already one case down. I didn't pull this up for you to see. Let me show you the defendant in this case, Jackson Blaving, right here. He's already pled guilty to one murder, and now He's going on trial for another one. He's really taking his chances here. If it were me in his spot, I've already pled guilty to one. Might as well go on and give it up on the other. But that's just my take. Next up, Jesse Vang. Jesse Vang pleads guilty. Excuse me. He pleads not guilty to charges related to the death of 3-year-old Elijah View. Now the video is only 19 seconds long. I won't do that one. Anyway, Jesse Vang, Elijah View's caretaker, pleaded not guilty to 3 felony counts, including hiding a corpse and 1 misdemeanor. The charges stem from the death of 3-year-old View, the boy who went missing from Two Rivers in February. Two Rivers, Wisconsin. Vang was the one to report View missing, according to police. Investigators confirmed in September that remains found on private property in Wisconsin were those of Elijah View. Vang appeared via Zoom for his arraignment Monday. Excuse me, this is last Monday at the Manitowoc County Courthouse. Manitowoc District Attorney Jacqueline LeBray said the state will have an offer to resolve Vang's case to his attorney by February 7th, 2025. My birthday, guys. Think about that one. Vang is scheduled for a scheduled conference at the Manitowoc County Courthouse on March 13th, 2025. Elijah's mother and Vang's partner, Katrina Bauer, is also being charged with 2 felonies, including chronic neglect of a child, consequences death, and 2 misdemeanors. Bauer's case will reopen for a scheduled conference on February 12th, 2025. I honestly believe that both had something to do with this. And let me go right to the chat. Let's see who's on and who's up. Juju Bones in the house. Welcome, Juju's. How you doing? I'm doing just fine. Fine. Hey, if you stick around long enough, we're gonna get to those verdicts in those verdicts, the parole hearing, all of that in tonight's edition. Like I started off. There were 6 cases that I'm covering tonight, and all 6 defendants have been declared guilty as charged. Stick around. As for Jesse Vang and Elijah View, in the Elijah View case, along with Katrina Bauer, I believe both of them are guilty of that little boy's death, and I want that little boy to get the justice he deserves. Next up, Brian Kohlberger's defense is arguing that evidence was illegally gathered. They're saying the documents allege Kohlberger was zip-tied after a no-knock warrant was served at his parents' home in Pennsylvania. And the saga continues.
But for
that Elijah's one of a number of cases that's close to my heart, and I was just saddened when I found out that the remains were his. I was hoping against hope that they would find that young man alive, but You know how those cases go. Excuse me, I got Lady Outlaw off on the side asking which case was I referring to. I was talking about Elijah View. They found out that his caretaker. They just found this. They just decided to go ahead and charge his caretaker and his mother on felony counts. Yeah, yeah, that's what I thought too. So we're gonna keep an eye on this case, and we'll get to that, and Juju Bones just said hi to you, sweetheart. All right, let me go ahead and take you to Court TV and the Honorable Judge Ashley Wilcott for more on the Kohlberger argument on illegally gathered evidence. Before I go there, let's see. Juju Bones, those were the hardest documents I ever read. Yeah, I totally agree. You gotta have a little. You gotta have something inside your heart to even treat a child that way. All right, like I said, now I'm gonna go ahead and take you to Court TV, the Honorable Judge Ashley Wilcott, as she covers the Brian Kohlberger defense argument of illegally gathered evidence. And as I'm doing that, I am going to put up a copyright disclaimer here. I'm going to take myself out of the shot and out of speech. That way, you'll hear Judge Ashley and everybody else that's in this interview.
First, we want to begin in Idaho, where a major motions hearing is underway in the Idaho student murders. Here's Court TV anchor Michael Ayala with a look at the death penalty in Idaho.
Murder in the first degree, maximum penalties, life in prison, or the death penalty.
Brian Kohlberger could get the death penalty if he's convicted of first-degree murder in the stabbing deaths of 4 University of Idaho students.
Do you understand the maximum penalty? Yes.
The new law in Idaho could mean execution by firing squad if Kohlberger is found guilty and sentenced to death.
We need to bring back the firing squad.
State Representative Bruce Skog co-sponsored the bill to make the firing squad a secondary method of execution in Idaho.
This firing squad is a backup method if we can't get the pentobarbital.
In recent years, pharmaceutical companies have filed lawsuits to prevent their drugs from being used in lethal injections. It's making it more difficult for states to carry out executions by lethal injection.
Pentobarbital does not have a long shelf life, so it's not as if we can stock up and hold on to it for years.
Idaho called off its scheduled execution of Gerald Pizzuto Jr. in December of 2022 after it couldn't obtain the necessary chemicals to put him to death. Pizzuto has been on death row for nearly 40 years after being convicted of murder in the deaths of an Idaho couple.
None of the firing squad executions, approximately 150 or so, in recent recorded history have been botched.
David Leroy is Idaho's former attorney general, now a defense attorney.
I think a good argument can be made that it's a humane method of execution. There is a cruelty factor, I think, of lingering between, as we have here in Idaho, 40 years and 7 years on death row, unknowing whether that sentence will be ultimately executed.
Skog says they look to Utah for direction. It's where the last firing squad execution took place.
There may be a panel of 5 or 6 persons with rifles, and one of them has a blank in it, so that they're not sure who had the blank.
There is no method of execution that will always work perfectly.
Robin Marr is the executive director of the Death Penalty Information Center, which studies the death penalty.
As long as we have human beings involved in that protocol, there are going to be opportunities for mistakes. And certainly there may be problems with the firing squad.
All right, let's bring in Court TV crime and justice correspondent Matt Johnson to get us caught up on everything happening so far. Always good to see you, Matt, especially here on set. Thank you for being in here. And we know a hearing is underway. Tell us, please, what are some of the biggest takeaways at this point?
It's been a long hearing, but it's so important as we inch closer to trial. Brian Kohberger's defense trying to get the death penalty off the table, even before his trial begins, set for summer of next year. Kohberger, accused of killing 4 University of Idaho college students 2 years ago this week. Today, his defense is arguing death by lethal injection or firing squad would be cruel and unusual punishment under the 8th and 14th Amendments of the U.S. Constitution. Take a listen.
Looking forward, we just don't have those answers yet. We don't know how that's going to unfold. I don't believe his execution is moving forward as is scheduled. And if we look at the immediate history in Idaho, and that's what I'm looking at when I'm standing before you representing Mr. Kohberger and saying to you that Idaho doesn't have a real means of executing someone. The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logston in our briefing, is that it sat on Idaho's books for years. And in 2009, it came off in light of the Bethea'S decision. When you think about it coming off in light of the Bethea'S decision, and you look at what's happened since the Bethea'S decision, and we're going to talk about that a little bit later today when we're talking about evolving standards of decency, we'll talk about how things have changed in this country since then. But for these purposes, when you look at that and you realize Idaho brings it back in 2023, they bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall from the media at least, that the construction's actually underway. But I may be wrong about that.
And that talks about understanding what a person is conscious and aware of when they face the firing squad. That's information that's important for the court when considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist.
And the judge right now taking all of this under advisement, but kind of signaling to what his judgment might be, saying that Kohberger, if he's convicted, the execution date would be decades away from now possibly, and we don't even know what means of execution will be available in the state of Idaho, Judge Ashley, at that particular time, if and when his execution date is scheduled.
Yeah, really good legal arguments. I don't envy the
Ann
judge.
Taylor is very good.
Yes, and
fighting
the judge,
for her client.
Ooh, but having to make this decision, Matt, I know he's taking that under advisement, as you mentioned. Now, there was a win for the defense. Tell us more about that.
It's pretty much the only victory and the decision that we've seen so far today. Kohberger was asked to attend all pretrial hearings in a suit and tie instead of a jumpsuit, and you can see right there, that's video from today. He won that motion. He was arguing through his attorney saying that the media attention, it would impact a presumption of innocence and the right to a fair trial.
I did hear information from security and from Ada County Transport regarding security measures that would need to be taken had the court allowed Mr. Kohberger to appear in civilian clothes. The state did not object to Mr. Kohberger appearing with civilian clothes. The court has employed security measures and is comfortable in terms of the security and flight risk related to Mr. Kohberger with those measures, and therefore has granted the defense motion to allow him to appear in civilian clothes.
So for all the pretrial motions, and there's still going to be a lot of them ahead, he can appear in suit and tie. These hearings are still going on, and of course this is happening there in the Ada County Courthouse. This is a change of venue, but you recognize that courtroom, Judge Ashley, very well. I spent a lot of time there because this is exactly the courthouse and the courtroom where Chad and Lori Daybell, they had their trials. That was also a change of venue there in Boise. And, you know, it's also interesting to note as they make their arguments trying to get the death penalty off the case, that didn't really work for Chad Daybell.
Yeah, what a great point and great analogy. There are a lot of good legal arguments being made, but again, we just don't know what the judge is going to do. And suit and tie, I'm not too surprised, state agreeing, but I agree with you. It's something the defense knows that they've won. Matt Johnson, thank you so much for being with us here on set. I want to welcome our guests for this hour, Circuit Deputy Solicitor April Sampson and former homicide prosecutor Melba Pearson. Thank you, ladies, for being with me today. Let's first talk about that suit and tie. Matt's excellent reporting and really the comment that hey, this is a win for the defense, but the judge said the state didn't object. I think this day and age, pretty much any defendant that requests that, if there are no security concerns, is going to be able to be in regular clothes because they are presumed innocent. Melba, your thoughts?
Yeah, so good afternoon, Judge Ashley. Always great to be on with you. And I think that this was the correct ruling here because, number one, it is going to affect his presumption of innocence. He is presumed innocent at this juncture. The state has not presented all of their evidence. The jury has not deliberated, so he's presumed innocent. And as such, he should appear as someone who is, you know, is innocent, basically. So you put on a suit and tie, and then you're able to at least have that presentation where you feel a little better about yourself, where you're not sitting in a jail jumpsuit in orange or stripes, whatever it may be in that particular jurisdiction, and everyone seeing you in that state and equating that with your guilt before any evidence has actually been presented. I think it's just a common decency thing, and I don't have an issue with it. If I was the prosecutor, I would agree with it as well.
Yeah, great points. I think it is common decency. Now let's turn to one of the harder arguments, April, and that is about the death penalty. And this is one of the few states where death by firing squad is an option. I know South Carolina is another one, but where do you stand on this whole argument and what the court might do with the death penalty or not?
And I think that's the problem that they're going to face, right, is we're talking about something that may or may not happen. And so I have seen, and I'm sure Melba has seen as well, where a judge will say, I am not going to rule. You have put the cart before the horse. There's no reason for us to be talking about this since we don't have a death sentence yet. So I think it is hard for a judge to make that decision. This judge can listen to all the arguments and say, well, you know what, I'm going to wait to see if we get to that point. Thanks for all of your hard work, but I'm not going to rule. I've had that happen many times where a judge does that, just so that it's all on the record, but it's moot at this point until or unless a jury determines that he needs to get death.
And I think, Melba, a presumption of innocence to already be thinking about the death penalty when theoretically you are innocent of the crimes as charged, I think that's a lot for a defendant to carry.
Absolutely. And that's why the defense is trying to take this off the table, because if you take death off the table, it doesn't mean that if he's found guilty, he's going to get no punishment. It just means he would serve the rest of his natural life in prison, likely without the possibility of parole. And so, you know, of course, there is a lot of debate around the death penalty and whether or not, you know, we should still be doing that. That's a discussion for another day. But the reality is that is the law in the state of Idaho, and that is the maximum. But if the judge decides to take it off the table, or if the state decides that they're not going to pursue death penalty, you know, that is an option. But the defendant has to carry the fact that, listen, he's rolling the dice big time. And this is not just, oh, I might get 20 years in prison. This is, I might die or I might serve the rest of my life in prison. So if there's any opportunity for plea negotiations, probably not the worst thing for him to be thinking about.
Yeah, absolutely.
Murder in the first degree, maximum penalties, life in prison, or the death penalty.
Brian Kohlberger could get the death penalty if he's convicted of first-degree murder.
Ladies and gentlemen, I gotta admit this right now, and I know there's a lot of you who feel the same way. On the one side, defense attorney Ann Taylor, she's good, too good. Which brings me to the other side of that. She's so good I can't stand her, which is why I made the comment. Is it just me, or is the defense attorney so good you can't stand them? Anyway, back to the subject at hand. And Kohlberger, they submitted an array of motions to suppress evidence in the case. In the motions filed on the week before last, the defense asked the court to suppress any evidence obtained by police during and after his arrest in Pennsylvania, arguing the warrant lacked evidence, lacked probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusions. Kohlberger's attorneys are also trying to dispute law enforcement's use of genetic evidence, claiming it was illegally gathered. The defense also claims that the warrants used to gather evidence, including for Kohlberger's car, home, cell phone, and more, were invalid. Without investigative genetic genealogy, or IgG, there is no case. No request for his phone records, no surveillance of his parents' home, no DNA taken from the garbage on his driveway in a gated community under a garbage collection ordinance, because the IgG analysis is the origin of this matter. Everything in the affidavit should be excised. Mr. Kohlberger requests the courts to suppress all evidence obtained by police via the warrant that permitted them to search his parents' home. The defense wrote in one of the motions, law enforcement failed to knock and announce before raiding the home, and the warrant lacked probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusions. Any statement made by Mr. Kohlberger are the fruit of the poisonous tree of the illegal arrest. The documents allege Kohlberger was zip-tied after a no-knock warrant was served at his parents' home in Pennsylvania, and was then surrounded by police at gunpoint. Law enforcement did not Mirandize him immediately. Instead, they waited until after he was transported in a police car, handcuffed, with at least two officers in the car, the defense argued. The state has until December 6th to respond to Kohlberger's motions. Then the defense has until December 20th to respond. A hearing on the discovery motions is scheduled for January 23rd, 2025 in Ada County. Earlier this month, Kohlberger appeared in court as his defense team argued motions to strike the death penalty from the case, as you just watched in the video. The judge has not yet released his decision on that. But as it does stand right now, Kohlberger could face the death penalty, and if that's the case, it could very well be by firing squad. Juju Bones responding to my earlier comment. She is good, but I don't think she's good enough to get him off on quadruple. That is a possibility. That is a very remote possibility, and given what he's charged with, I could end up doing another edition of Guilty as Charged and having Kohlberger as one of the subjects. Just saying. Let's see. We have another trial that's going on right now. Brian Camp is on trial in Massachusetts, charged with manslaughter for the death of Jonathan Letendre, who allegedly broke into Camp's home. This is known as the Jealous Ex Shot Dead trial. Alright. So, a Massachusetts man is standing trial for the shooting death of his girlfriend's ex-boyfriend. 24-year-old Brian Camp is charged with manslaughter for the death of Jonathan Latendre, 27 years. According to testimony, Latendre broke into the home Camp shared with his girlfriend and their 2 children on December 27, 2022, and attacked Camp as he slept. Brooke Janik's 911 call captured a nearly 20-minute physical altercation between Camp and Latendre. In the call played in court, Janik is hysterical as she describes the 2 men fighting, and the first gunshot is heard. Approximately 8.5 minutes later, a second shot is recorded. In their opening statement, prosecutors said Camp's first shot was legally self-defense, but argued the second shot was unnecessary and more force than reasonably needed to defend himself. Camp's defense argued Latendre was still a threat and moving when the second shot was fired. A medical examiner testified to recovering handcuffs from Latendre's pocket during autopsy. Authorities also recovered a knife from his jacket that was found at the scene in the days after the shooting. An investigation revealed Janik and Latendre, who worked together, briefly dated while she was separated from Camp earlier that year. Janik ultimately ended her relationship with Latendre to get back together with Camp. Court documents detail text messages Janik received from Latendre that reveal he was upset about their breakup. Camp has pleaded not guilty, and he has been out on bond awaiting trial. That's coming from a report from WWLP. And as you can see, this is all the entire breakdown of the first 4 days of testimony. It'll pick back up. I will assume on tomorrow, and it will be a short week of court because of Thanksgiving holiday. So still, I will try to keep up with this case as much as possible and bring you the verdict when it comes in, right here at Bethea'S Byte Reloaded. But for now, this is what happens with this is what happens when you have a woman, a current relationship, and an ex-relationship, and those little clashes like that happening. So anything is possible. It's a good thing. It's the only good thing about this is that Camp is only being charged with manslaughter and not first-degree murder. Next story: the prosecutors saying that they want the Michigan school shooter's sentence to remain in place. Prosecutors are asking urge the judge to reject the Michigan school shooter's request to withdraw his guilty plea in the deaths of 4 students back in 2021. I won't play that video. I won't play that video of Ethan Crumbley pleading guilty. But I will give you the breakdown of this story. Prosecutors urge the judge to reject the Michigan school shooter's request to withdraw his guilty plea in the deaths of 4 students in 2021. 18-year-old Ethan Crumbley is currently serving a life sentence for the Oxford High School shooting, but his new appellate lawyers want to start over, arguing that he had poor mental health when he waived his right to trial and pleaded guilty to multiple charges at age 16. The Oakland County Prosecutor's Office, however, said Crumbley falls far short of the Michigan legal threshold to withdraw a guilty plea. Crumbley cannot withdraw his plea merely because he has changed his mind, Assistant Prosecutor Joseph Shada said in a court filing. Shada noted that Crumbley signed a document acknowledging that he had discussed the guilty plea with his lawyers and that any questions were answered. In a separate filing, prosecutors said Crumbly's life sentence should stand too. His appellate lawyers want Judge Kwame Rowe to hear new evidence of a turbulent childhood and exposure to alcohol during pregnancy. Crumbly's life sentence is proportionate and constitutional, even for an individual who claims to have, quote, fetal alcohol disorder, Shada wrote in opposition. Right now, it's not known whether Rowe will make a ruling. Crumbly was 15 when he brought a gun to school and killed 4 students and wounded others. Earlier that day, his parents were summoned to discuss violent drawings and agonizing phrases written on a math assignment. They didn't take him home, and no one checked his backpack for a gun. James and Jennifer Crumbly are serving 10-year prison terms for involuntary manslaughter. They were accused of making a gun accessible at home and ignoring their son's mental health. They were the first U.S. parents to be convicted in a school shooting committed by their child. Meanwhile, the parents of the students killed at Oxford renewed their public plea for a broad investigation of the shooting. They said it could help Michigan schools keep students safe. So let me get this right. Ethan Crumbly changes his mind and now wants to plead not guilty to going to school with a loaded weapon, shooting as many people as he can, and killing 4 people. Ethan Crumbly, are you kidding me? It's because of what you did that's where you are in the first place. So what makes you think, just because you say, oh no, I changed my mind, that your situation is going to be any different right now? I don't see the judge changing his mind. I don't see the judge changing his ruling. I don't see Ethan Crumbly getting out of prison anytime. Forget anytime soon. Anytime. And now, it's time for a brand new edition of Did He Do It? First up, the judge bars prosecutors from using notes from Diddy's cell phone for now. Let's see, can I use this? No, I can't. No, I can't. It's too short. The judge in Sean Diddy Combs' federal sex trafficking case ordered prosecutors to get rid of copies of notes that were found in Combs' jail cell, barring the government from using them as evidence in its upcoming bail hearing. Lawyers for the music mogul requested a last-minute hearing to find out how federal prosecutors obtained the handwritten notes and if they breached Combs' attorney-client privilege by viewing them. The notes in question, 11 pages from a pad marked Things to Do, that prosecutors say a jail staffer photographed in Combs' cell and shared with the government. Judge Aaron Subramanian told prosecutors to eliminate references to the notes from their arguments in a bail hearing that's scheduled so that the hearing can proceed while the attorneys litigate the bigger issue of whether the notes are admissible in other proceedings, chiefly a pending grand jury investigation of Combs for possible witness tampering and obstruction of justice in the sex trafficking case. Combs pleaded not guilty in September to the charges for which he is currently awaiting trial: racketeering, conspiracy, sex trafficking, and interstate transportation to engage in prostitution. He is accused of using his celebrity status and the resources of his business empire to coerce women into participating in drug-fueled orgies with male sex workers known as freak-offs. Combs appeared in court without leg shackles for the first time, per the judge's order. He wore a big smile on his face as he entered the courtroom and hugged each of his attorneys. He smiled at the gallery, waved at a courtroom sketch artist, and chatted animatedly with his attorneys before the hearing began. Federal prosecutors said in court documents that a Bureau of Prisons investigator found the notes during a facility-wide sweep for contraband at the Brooklyn Metropolitan Detention Center in late October. The government said the sweep, which was planned before Combs arrived at the facility, included interviews with inmates and searches of their bunks for contraband. Which is how the investigator came across Combs' notes. Before looking at the notes, prosecutors said they sent them to a filter team within the U.S. Attorney's Office to review them for privileged content, and then the filter team sent redacted portions of the notes to the trial attorneys pursuant to a covert grand jury subpoena. According to prosecutors, among Combs' benign notes to self on finances and family birthdays were notes about getting dirt on witnesses and alleged victims in his sex trafficking case. Prosecutors cited the instances in their well-written arguments opposing Combs' third bail request. The first time Combs' attorneys say they learned of the sweep or the photographed notes. Combs' lawyer, Mark Agnifilo, called the MDC sweep a pretext for a raid targeting Combs. The judge granted the defense request for an order to preserve MDC surveillance footage of the raid as part of a fact-finding into what led up to the seizure of Combs' notes. Agnifilo said all of Combs' notes are privileged because they arose from attorney-client privilege, attorney-client discussions about trial strategy that were not intended for prosecutors. We're studying this man's life, Agnifilo said. This is not a single-day, single-event case. This is not enough. This is not a single-day, single-event case. This is an indictment of this man's life, Agnifilo says. He argued the legal significance of the notes should have been evident to prosecutors, not only from their content, but because the notepad itself was labeled legal in handwritten letters. To make his point, Agnifilo presented the notes to the judge among a stack of yellow legal pads and paper-filled envelopes, asking him to take note of handwritten legal heading. If it's in this legal file, it's discussed with his lawyers, Agnifilo said. Federal prosecutor Clissy Slavic said in the hearing that simply writing the word legal on a pad doesn't make it privileged material. She argued the government did the right thing by sending material to be reviewed by the filter team, out of respect for Combs' attorney-client privilege, even though evidence suggests Combs is trying to interfere with his sex trafficking case with alleged attempts to contact potential witnesses and viewers. Witnesses and accusers, excuse me. Slavic confirmed that the BOP investigator who searched and photographed the notes is the same investigator assigned to monitor his calls and emails in the grand jury investigation. She insisted that no one from the prosecutor directed the investigator to search for or collect items from Combs during the BOP sweep. When the judge pressed Slavic to explain why her team did not immediately hand over the notes to the defense, Slavic leaned on the grand jury investigation. We have no obligation to alert them to an investigation of an ongoing criminal matter, she said. Judge Subramanian did not rule on whether the notes fall under attorney-client privilege. He said the government's filter team can hold on to the photographs of Combs' notes until he rules on whether they are privileged communications or fair game for the government's grand jury investigation. So, let's see. Juju Bones says, I would like to know other celebrities involved. You know it is more than him that was involved. You're right. You're right, because the last time we had a report like that, they didn't name names, but there were others involved. Like you, I want to know. Like the old commercial used to say, inquiring minds want to know. Anyway, like I'm saying, I'm like to find out exactly will that information is fair game, or is this just another part of attorney-client privilege? We'll have to wait and find out. And just a little bit later, I have another brand new edition of Did He Do It? So stick around for that. All right, here we go. We have the first of our guilty as charged cases that we're covering. We're going to take you to the courtroom right now in Georgia, where Chloe Driver stood trial in the case of where she's accused of killing her 13-month-old daughter Hannah.
Welcome back to Court TV Live. We have a verdict in the case against Chloe Driver.
All right, now that I got you set up for that, I'm going to mute. I'm going to stuff out the shot, and then you're going to hear from Ted Rollins covering this case. And as you can see on your screen, the verdict is in. The jury has reached a unanimous verdict. We're going to take you into the courtroom right now to learn Chloe Driver's fate.
Welcome back to Court TV Live. We have a verdict in the case against Chloe Driver, the young mother accused of killing her daughter Hannah. 1-year-old little Hannah stabbed to death by her mother. She admits she did it, but the defense here was not guilty by reason of insanity. Will the jury buy it? Let's go into the courtroom and find out what the verdict is.
Thank you. You can be seated. Mr. Foreman, has the jury reached a verdict?
We have, Your Honor.
Is it signed and dated by you as foreman?
Yes, it is.
All right, if you could give the verdict form to the bailiff, I will inspect it before I ask you to publish it. He'll give that back to the foreman. Mr. Foreman, if you will stand, Mr. Driver and counsel, if you will stand, if you will read the jury's verdict, please.
For each count below, we, the jury, find the defendant, count 1, malice murder, guilty beyond a reasonable doubt, but mentally ill. Count 2, felony murder, aggravated assault, guilty beyond a reasonable doubt, but mentally ill. Count 3, felony murder, cruelty to children in the first degree. guilty beyond a reasonable doubt but mentally ill. Count 4, aggravated assault, guilty beyond a reasonable doubt but mentally ill. Count 5, cruelty to children in the first degree, guilty beyond a reasonable doubt but mentally ill. So found this 20th day of November 2024.
Thank you, sir. Mr. Bailiff, if you will allow counsel to inspect the verdict form. You may be seated, counsel. Anything else of these jurors?
No, not for the state.
All right. Members of the jury, this case will be set for sentencing on another day, likely either to be December 12th or December 18th. I'm going to confirm that with counsel after we excuse you. You are welcome to attend the sentencing hearing if you would like to. You are welcome to contact the clerk's office to find out what the sentence is after sentencing if you prefer to do that. Throughout this trial, I have cautioned you about not talking to others and not getting any media information about the case. You are now free from that. You may talk to one another or anybody else you'd like to about this case, but only if you would like to. You're not required to have any discussions with anybody, and that includes counsel or the media. And I want to say just a word. This is one of the first experiences that I have had with the televising of a trial. And what we know is that people, literally around the world have been watching us and commenting on what has transpired. And those of us, who do this for a living, we expect that. We understand that there are going to be comments, and some of them favorable, but some of them not. And we know that that's not part of your job, and that's not what you are used to. I am not in any way commenting on your verdict, meaning I have no position in favor of or against it. But what I know is that you have worked really hard. You have dealt with some unpleasant issues. You have been timely. You have, done everything that we have asked of you as far as, showing up and being here and paying attention. And so we appreciate that. We know that you've missed a lot of days of work, that you have had to reschedule appointments, that you probably had to ask a friend for childcare or something like that. And so we respect what you have done very much. And if you see comments to the contrary anywhere out there, know that everyone in this courtroom understands how hard you have worked and that we appreciate it. So thank you very much. And with that, you are free to leave.
Okay, there you have it. Guilty but mentally ill on all of these charges, meaning the jury believes that, and the defense agreed, that Chloe Driver was responsible for her daughter Hannah's death, but they believe that she was mentally ill at the time of the commission of this. This is different than not guilty by reason of insanity, which is also on the plate. Let's go back into the courtroom.
The sentencing hearing in this matter?
I don't think it would be lengthy, no, Your Honor. No, I don't think it'd be lengthy either. The only thing that I can potentially envision is if Ms. Renee Driver wanted to speak on behalf of her daughter, I would ask the court to maybe entertain the possibility of allowing her to do that via Zoom, which would be probably the only witness that we would have at that point in time.
Yeah, if they can't get up here, but we'll try to get them here, but if they can appear by Zoom if necessary, that'd be great. Either of the 2 days that the court suggested, I think probably are 12, but Trifley says 12 is better for her, so it's fine by me.
I have no conflict on the 12th.
All right, this case will be set for scheduling on sentencing on December 12th at 9 o'clock. I'll certainly entertain a request to have witnesses appear by Zoom if that is necessary. To accommodate the witness, Ms. Driver will remain in the custody of the Cherokee County Sheriff's Office. Anything else we need to take up today?
No, Your Honor. No, Your Honor.
All right. Thank you.
And we need to see you.
Yes, thank you.
All right, now a lot of reaction from the defendant, Chloe Driver. She was escorted from this courtroom. The jury taking over 2 days, just about 4 hours, I believe, deliberations. They started today with about an hour and a half, so just over 3 hours, it looks like. And they determined that she was guilty on all counts, but mentally ill. And they acknowledged that she suffered from mental illness, and this was a big part of the defense in this case. Here to talk about it, Matt Johnson, who has been in that courtroom and has been monitoring this trial for us. He is on set with us. Cannon Kearney is in New York, defense attorney. Welcome to both of you. Matt, you were there watching this. Your reaction to this verdict, the jury seeming to acknowledge really the obvious, that this woman had some sort of mental illness, but also is guilty.
Well, I mean, it's a complicated case, and this is one to which the jury wasn't out for very long. When you have this area north of Atlanta where we just covered another trial, the burn pile murder trial with Melody Ferris, that deliberations went 3-4 days. There was a hung jury at one point in time, and then they came back. This one, they were looking at a lot of different other factors involved in this case because of her pleading not guilty by reason of insanity. And quite frankly, they weren't out for very long. Coming together in this very conservative part of Georgia and deciding this guilty verdict.
Cannon, not guilty, but mentally ill. It's a bit of a caveat, but it's not guilty by reason of insanity. She will be in the custody of the Department of Corrections now, not being shipped off to a mental hospital because of the Explain, if you will, what this does to her case moving forward in terms of treatment for her, and et cetera. This was a loss, you have to argue, for the defense, but also an acknowledgement by the jury that this woman did have some issues and does.
Good morning, Ted and Matt. I would say that the defense would feel some form of a loss. However, they should feel also that this is somewhat of a quasi type of verdict, meaning that at this point, since the mentally ill was connected with the guilty, she will be put in some type of treatment while she's incarcerated. This does also mean that since she's convicted, her name will be clearly someone who murdered her daughter. Whereas if she got the not guilty by reason of insanity, she would have not had any conviction at all. So here the community is ensuring that someone who has this type of mental disability, this type of mental illness that actually caused her to murder her own child is not within the community, meaning that she is going to be incarcerated somewhere. She will be getting the treatment that she needs, but she will not be able to harm anyone else.
Yeah, she'll be sentenced to prison, but given out of the gate the necessary treatment according to whatever the prison physicians believe is necessary to treat her mental illness. This Benjamin character, he was the sensei, the guy that scooped her up at a bus stop when she was 16 years old. He's scooped up other unsuspecting young women. He's out there free as a bird, and he continues to do what he does, drink his own urine, and just really ruin lives, in my opinion. Yet he is not facing the same consequences as Chloe Driver. When you were in that courtroom, was there a sense that, because the state didn't call him, and neither did the defense, they didn't want Benyama in the courtroom, that she was a victim? Did you feel that she was a victim, that the jury, did you think, had some compassion? It seems as though with these verdicts.
Well, it appears with this verdict, yes. And I mean, there was a lot of very strange testimony in this particular case that made it very unusual, right? I mean, you had the whole polygamy aspect of it all with Benjamin Z, or whatever else he would like to be called. He has several names. He's not in custody. We heard from his first so-called wife that testified for the defense, saying that she was badly beaten and abused in the basement of a home. Benjamin's dad had to intervene. She was duct taped. She could hardly breathe, and she was on death's door. So that's someone that was already also abused by this person who met him at the age of 17. You had testimony about this cult not believing that people in the world were real, except something like 165,000 people. The rest of everybody else was robots. You had a lot of details about all of Chloe Driver's search history leading up to the murder of her daughter, which included things like, can God forgive me? The view on multiple wives, how to snap a neck. She was clearly thinking about death before this act. These are all things that really played a part in deliberations, and this jury was paying close attention to also how she was behaving at that defense table. With this particular defendant, she would break down time to time, including with testimony of her mother, who tried to be one of the few people that tried to save her. There was the Good Samaritan that tried to save her, but her mother really tried to save her as well, even after she ran away from home, because she saw the control of this person, Benjamin, who the state has called a cult leader.
Yeah, and Cannon Kearney, we've seen these cults manifest in other criminal cases in different forms, and you go all the way back to Charles Manson, where you had someone that's able to take unsuspecting young malleable brains and bring them to their own twisted world. And I would argue that everybody in the cult maybe thought this was a non-reality world, except Benjamin. He used that to have 3 women in his bed every night. But Cannon, why is this? It's legal what he's doing, right?
It is legal. It's just unfortunate that these cults or these individuals, they use their power to have these young women to have these delusional thoughts, or they prey on women who already have delusional thoughts. So unfortunately, he was not the individual who was tried. I don't know how much of a conviction that he would have been able to get anyway. But as Matt said, it appears that not only is the community, but the jury is really trying to assist this young woman by ensuring that she now can get the mental health that she needs. Unfortunately, she'll just be locked up.
And Cannon, as a follow-up, the nature of this crime, a 1-year-old little girl, Hannah, 13 months old, murdered by her own mother. This was not something that the jury was going to let her escape it. And people don't, let's face it, we're all skeptics. And if you're thinking, well, not guilty by reason of insanity, she won't have to pay for it. And jurors don't really get the full story about what does happen to someone in that situation. But Cannon, not surprising that they would have not let her off the hook, I guess.
I totally agree, Ted. Essentially here, it's clear that the jury is saying that since they have this somewhat quasi-conviction, that they are holding her accountable and that they are ensuring that the rest of the community does not have to deal with her craziness.
Yeah, and Matt, this is a community, this is north of Atlanta, Georgia. You were there in this county at the courthouse. It's a pretty conservative area.
conservative, very family orientated. I mean, this is a crime that had people talking in this community, and quite frankly, once we started to air it across the world, people are just in shock over what happened here. And then hearing that testimony that she felt like she had to kill her child because she felt that she herself, Chloe Driver, was the embodiment of all the sin in the world because she was being brainwashed, and by breastfeeding her 13-month-old child, she felt that all of her sin was going into the child, and that's the reason why she was having delusions of killing her. This is what the defense put forward in their case. She was someone that was evaluated 3 times, and also evaluated by the court by an independent forensic psychologist, which we don't normally see, to render this decision. So we had 3 evaluations there. She's going to be evaluated once again. She's going to be sentenced on the 12th of December, we know. And, reading with Georgia Law, hearing from field producer Tiffany Smith, we're hearing that a guilty in the state of Georgia but mentally ill verdict is legally the same as a guilty verdict, which means that the defendant will be sentenced and incarcerated in the same way as someone found guilty of the same crime. So she's probably not going to end up at a Club Med type mental facility. She's going to end up at a high security facility, but on drugs.
Right. She'll be treated, but she'll be in prison, not a mental hospital. Cannon, stand by. Thank you. Matt, thank you. We're going to get a break here. Again, the breaking news at this hour: Chloe Driver guilty, but mentally ill of all charges. She will be sentenced on the 12th of December, a case we've been all watching very closely.
Here, folks, Chloe Driver found guilty but mentally ill on all charges related to the death of her 13-month-old daughter Hannah. She will be sentenced on December 12th. And honestly, I can't think of any. I hope she does get all the help she really desperately needs. Next case on the docket. There's an arrest in the 2023 murder of Mercedes Vega, who was found dead in a burning car. Sincere Hayes was arrested and charged with the murder of 22-year-old Mercedes Vega, found in a burning car off of I-10. This is out of Maricopa County, Arizona. The Maricopa County Sheriff's Office has made an arrest in a high-profile April 2023 murder case of 22-year-old Mercedes Vega, who was found in a burning car off of Interstate 10 near Tonopah. MCSO announced the arrest of 22-year-old Sincere Hayes in connection to the case. The Maricopa County Sheriff's Department said Hayes was arrested on November 11th in Tennessee. Maricopa County Sheriff's Office is working with the Maricopa County Attorney's Office to get Hayes extradited back to Maricopa County. They tell Scripps News Phoenix that they expect more arrests to come. Scripps News Phoenix obtained an extradition waiver from Hamilton County officials. It says Hayes is facing a first-degree murder charge in Maricopa County. The county attorney's office did confirm Hayes is facing a first-degree murder charge in Maricopa County, among other charges. I have been advised he turned himself into Hamilton County Jail, said the Hamilton County Public Information Officer, J. Matt Lee. This is why it shows our agency as the arresting agency. The date of Hayes' arrest was November 11, but the Maricopa County Sheriff's Office announced the arrest a week later. Records from Hamilton County also show Hayes was arrested for multiple other incidents in Tennessee this year. Court documents show those both involved firearms, and Hayes had a tentative court date in December. Vega's parents, Erica and Tom Pillsbury, believe their daughter was taken from her Tempe apartment parking garage. The medical examiner's report showed that she had blunt force injuries and was shot in the arm. The report also said bleach was found in the 22-year-old's throat. I've always said to her, I've got her back, Tom said at a walk in honor of Vega in April. It will not become yesterday's news. The car Vega found was outside off of Interstate 10 was not her own. That's according to the Pillsbury's to Scripps News Phoenix. Their daughter's car was found dumped not far from her Tempe apartment. Vega was described as a loyal friend whose smile can be seen in many of the photos shared by loved ones. Her family says she danced a few nights a week at a club. Right around 1 year after her death, the Maricopa County Sheriff's Office released small new details. Scripps News Phoenix was told Vega had abruptly canceled her plans the night before she was found dead, apparently telling someone she was going to work. The one thing we will do is we will not rest until someone is convicted of my daughter's crime, Tom said in August. I will not be quiet. My wife will not be quiet. The same month, Maricopa County Sheriff's Office confirmed for the first time they had identified persons of interest in the case. The Sheriff's Office also confirmed video of Vega walking in what appeared to be her apartment parking garage was part of the investigation. The video, family believed, captured one of the last times the 22-year-old was seen alive. Vega's family has been in and out of court following her murder for another case from October 2020. She was the victim of an armed robbery in Phoenix years before her murder. Erica says she remembers rushing to Vega's side after the robbery. The 22-year-old's mom told ABC 15 that prompted her daughter to move to the Tempe apartment. Before she was killed, Vega picked suspect Cujo Young out of the lineup and wrote a victim's impact statement. After delays, Young's attorney told the judge in October that plea negotiations were still ongoing. Vega's family is hoping an end to the robbery case is around the corner. Maricopa County Sheriff's Office has confirmed the 28-year-old is out of custody, but on an ankle monitor when Vega was murdered. There is no known connection between Young and Vega's murder case. So now that we have an arrest, all we got to do now is see what else is going to become of this. Or as a private detective I watched on TV would say, we'll shake the tree and see what falls out. Alright, now we're going to go back onto the docket and see what I have next. Ladies and gentlemen, round 2. Susan Smith is on her parole hearing. It's Susan Smith's parole hearing. She'll tell the parole board that, quote, I know what I did was horrible. The question is, does she show remorse? And does she show enough of it to grant her parole? I'm going to take you.
Smith is the woman you see there. She murdered her two little boys, 3-year-old Michael and 14-month-old Alex, by strapping them into their car seats and letting.
All right, we'll try that again. We're going to take you to News Nation with coverage of this case. And so stand by. The copyright is up. I'm gonna mute and jump out.
Smith is the woman you see there. She murdered her two little boys, 3-year-old Michael and 14-month-old Alex, by strapping them into their car seats and letting the car roll into a lake. The parole board unanimously said no. They sent Susan Smith back to her prison cell. And we are hearing today that she did not go quietly, apparently. An insider at the all-women prison told reporters that Smith was furious when she found out that she wasn't going anywhere for at least another 2 years. Here's part of what that eyewitness said, quote, "She was pissed. She was angry, crying, waving her hands, very agitated. It looked like she threw a tantrum." One of the many people who showed up in person this week to urge the parole board to keep Susan Smith locked up was Kevin Brackett. He is the solicitor for South Carolina's 16th Judicial District and has had Susan Smith's murder case on his desk literally his entire career. And Kevin was standing on the banks of John D. Long Lake 30 years ago when Susan Smith's car was pulled out with the bodies of Michael and Alex still inside. And he was on the prosecution team that sent Susan Smith to prison with that life sentence. And he joins me live now. Kevin, it's nice to see you. First of all, what do you make of her apparently having this outburst and apparently crying as she was on her way back to the prison cell?
It's no surprise to anybody who spent any time around her during that time period, during the trial, during the hearings leading up to the trial. She's never cared about anybody but herself. So, it's no surprise that she wasn't even thinking about what she did to land her where she is, and why that terrible crime is going to keep her there for at least another 2 years. She's never cared about anybody but Susan.
Do you think she actually thought she was going to get out? I mean, do you think she actually believed that? Because everyone on the outside, it just seemed like there was no way with this evil woman who killed her kids.
Yeah, she probably did, but she's a sociopath. So, she can't imagine that anybody out there doesn't love Susan as much as she loves Susan. So, it's probably not, it's not beyond imagining that she really truly believed that they were going to, take pity on her and see her fake tears as real and feel sorry for her and think, oh, this woman truly is remorseful and has reformed herself. That's just who she is. During the trial, it was, and the hearings leading up to the trial, but especially during the trial, because there was a jury. And so she knew she was on stage during the trial. But when the jury was out of the courtroom, while we were taking care of business that they didn't need to hear, she would be smiling and laughing and talking to her attorneys and carrying on, and there was no big deal. The minute that they walked in the courtroom, she would immediately go into this sad pose and, sit there with her head down like she was deep in thought about what, how she'd screwed up and how sorry she felt and how sad she was. It was almost, the only thing we were missing was the guy on the set who does the, action. Other than that, it was like a movie set, and she was acting. And so, it just took me right back being at the parole hearing to 30 years ago, being in court with her.
Yeah, that must have been a really strange feeling for you. I guess I don't know if I was surprised, even if she was faking it. I thought she would apologize to David, the children's father, her ex-husband. I thought that he deserved that. I don't know if it would really matter to him at this point, but she didn't apologize at all.
No, she didn't. And who knows, maybe she'll up her game next time, parole hearing 2.0, and try to put a little bit of that in there. But I honestly don't think that, given the seriousness of what she did, the horror, not only what she did to the kids, but what she did to the community and this whole country, lying about what happened. I mean, it was just such a heinous crime, and the cover-up that followed. It was just really just a terrible, terrible crime. And I hope, and I told the parole board this, that I hope she spends the rest of her life in prison, and every 2 years she gets to repeat her tantrum as they take her back to her cell. And as I told the parole board, I hope her hopes are dashed every 2 years, just like she dashed David's hopes for a happy life with his children.
Thanks for watching. Go to joinnn.com to find News Nation on your screen. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.
Smith is
Wow. Let me go ahead and that's all Susan Smith gets from me. If she's looking for sympathy from this guy, forget it. She, as you heard from the prosecutor who put her behind bars, he had no sympathy for her either. Yep, Susan Smith denied parole, and honestly deserved it. All voting members of the South Carolina Parole Board did not kill her mom Susan Smith's bid to be released from prison after serving 30 years. Smith appeared before the Parole Board for the first time after reaching eligibility. She was sentenced to life in prison in 1995 for killing her sons, 3-year-old Michael and 14-month-old Alex, by drowning them in a family car which she rolled into a lake. First of all, I want to say how very sorry I am, Smith told the board, choked by tears. I know what I did was horrible, and I would give anything if I could go back and change it. I love Michael and Alex with all my heart. When the board asked Smith whether she had a message for those who searched for the boys after she initially lied and said they were kidnapped during a carjacking, Smith said, "I'm sorry that I put them through that. I'm especially sorry to the divers that had to find them. I wish I could take that back. I really do. I was just scared." Right. Smith's attorney Tommy Thomas spoke on her behalf at the hearing and told the panel, "It's a mental health story. It's about the dangers of untreated mental health. It's about the lack of insight, the lack of diagnosis into mental health, and it's about stigmas." Thomas told the board that Smith had attempted to take her own life several times, but before she killed her children and while behind bars for their murders. Thomas said that part of Smith's motivation to appear at the hearing, beyond seeking freedom, was a desire to get the truth out, saying that the murders were not about the love of another man. At Smith's 95 trial, prosecutors suggested that the reason she killed her children was because she was having an affair with a wealthy man who did not want kids. But Thomas said that the motive was never proven at trial and was in fact abandoned by the state. Rather, Thomas said the murders were the result of multiple stress points that converged all at the same time, but did not offer any further explanation. As for what she might do after leaving prison, Thomas told the board that Smith would like to work with animals and wants to live a quiet life. Tommy Pope, who prosecuted the case in 1995, spoke at the hearing and urged the board to keep Smith behind bars. While Pope had asked the jury to sentence Smith to death, the jury elected to spare her life and sentenced her to life in prison. But Pope said the jurors didn't know that she would ever be eligible for parole. Susan has always focused on Susan, Pope told the board. The jury believes Susan should have to reflect on what she did to Michael and Alex. that she should have to spend the rest of her life thinking about what she'd done. David Smith, Susan's ex-husband and the father of the two boys, urged the panel to keep her in prison, saying the grief over losing his children nearly drove him to take his own life. I understand back in 95 that the state's law meant life in prison meant 30 to life, and now that's different. But at that time, that's what counts. But ultimately, to me, it's only 15 years per child, her own children. It's just not enough. Under South Carolina law, Susan will be eligible to appear for a parole hearing every 2 years. David told the board he planned to see them in the future. I will be here every 2 years going forward to ensure that their death doesn't go in vain. Alright, to the chat. Juju Bones said she wanted to get rid of her kids because of the affair. In my opinion, yes, although that wasn't proven in court. Yeah, that was the motive. That was the motive. Now, after getting the report of the decision of the parole board, let me say this. Like I said earlier, look at my face. This is the face of somebody that has absolutely zero sympathy for Susan Smith. None. Zip. Zero. This is the same guy who watched this case unfold when the report first came out that the children were merely missing. This is the same guy who filed the case when Susan Smith made the accusation that a black man carjacked them with the children inside, only to find out later that it was Susan Smith who drowned those children. Now look at my face one more time. In fact, let me see if I can get close enough for you all to see. Look in my eyes. What do you see? I'll tell you. No look of sympathy. Note that. So if anybody ever asks you, if anybody asks me in the future, Outlaw, you have no sympathy for Susan Smith? Why not? Look at everything that transpired, and then ask me again if I have sympathy for Susan Smith. The answer is a resounding no. None. And anybody wants to, you can hold me to that, quote me on it. I don't mind it. I'll tell everybody the same. I have zero sympathy for Susan Smith. Period. Point blank. And here's somebody else I have no sympathy for. No, actually, I'm going to go ahead and adjust that. I have sympathy for the parents and the loved ones of Laken Riley. So if I have sympathy for them, guess who I don't have any sympathy for? We're going to go right now back to the courtroom. We're going to get the verdict first. The verdict for Jose Ibarra, who is on trial for the murder of Laken Riley. And he's got 10 counts under his belt.
But for now, we're getting some breaking news out of...
All right, now that I'm getting that set, I'm going to go once again. I'm going to mute, take myself out the shot, and the next voice you're going to hear is that of Julia Janae covering the verdict in Georgia versus Jose Ibarra.
But for now, we're getting some breaking news out of Georgia. We have been following the murder trial in the death of Laken Riley. Jose Ibarra is the defendant there, and the judge has been deliberating. Let's go in live with his decision on this case.
You may have seen me. I make notes during the trial. I probably filled up 2 legal pads full of notes during the trial, but the closings I want to just listen, and that's what I did. But I wrote down 2 things in the closing. One was a statement by Ms. Ross that the evidence was overwhelming and powerful. And then I also wrote down what Ms. Beck said, that I'm required to set aside my emotions. That's the same thing that we tell jurors in what, and we're giving them their job. I would, that's the way I have to approach this. And I did. Both of those statements are correct. I'll now announce the verdict. In the state of Georgia versus Jose Antonio Ibarra, case SU 24CR0323, count 1, malice murder. I find the defendant guilty. Count 2, felony murder. I find the defendant guilty. Count 3, felony murder. I find the defendant guilty. Count 4, felony murder. I find the defendant guilty. Count 5, kidnapping with bodily injury. I find the defendant guilty. Count 6, aggravated assault with intent to rape. I find the defendant guilty. Count 7, aggravated battery. I find the defendant guilty. Count 8, obstructing or hindering a 911 call. I find the defendant guilty. Count 9, tampering with evidence. I find the defendant guilty. Count 10, peeping Tom. I find the defendant guilty. I certainly will allow both sides to look at this if you want to do it. The next step is sentencing. I'm prepared to go forward with that now, or if either side suggests that you need a few minutes, an hour break or something to do that, then I'll certainly do that as well. Consider that.
We have one more.
Sure.
Thing will break on after the news meeting.
I understand.
We'll come back for something.
I understand. We will recess till 12:30. Recess till 12:30. Will that work?
Yes, sir. Yes,
sir. Okay, thank you.
Judge Patrick Haggard delivering his verdict there. Guilty of all charges for Jose Ibarra. Justice served for Laken Riley, that 22-year-old nursing student who was just jogging, who was minding her own business that day when the prosecution says she was hunted down. A man who just wanted to hunt females.
All 10 charges, and Jose Antonio Ibarra was found guilty on all of it. All of it. I'll run it down again. Again, malice murder, guilty. Felony murder, count 1, guilty. Count 1, malice murder, guilty. Count 2, felony murder, guilty. Count 3, felony murder, guilty. Count 4, felony murder, guilty. Count 5, kidnapping with bodily injury, guilty. Count 6, aggravated assault with intent to rape, guilty. Count 7, aggravated battery, guilty. Count 8, obstruction or hindering a person making an emergency phone call, guilty. Tampering with evidence, guilty. And peeping Tom, guilty. So what will his sentencing be? Let's jump right in and find out now.
You ready? With that, Mr. Ibarra, if you will please stand. Count 1, malice murder. I sentence you to life without the possibility of parole. Count 2 will be vacated as a matter of operation of law. Count 3, vacated by operation of law. Count 4, vacated by operation of law. Count 5, life in prison consecutive to count 1. Count 6, 20 years to serve consecutive to count 5. Count 7 will merge with count 1. Count 8, 12 months consecutive to count 6. Strike that. 12 months, but I don't want it to 6. It's just going to be consecutive. Count 9, 12 months consecutive. Count 10, 5 years consecutive to count 6. So that would mean the misdemeanors would come after the felonies. That will be the sentence. Mr. Ibarra, I will advise you that you have 30 days from today to seek any post-judgment relief in the form of a motion for a new trial or appealing this case directly. If you make a motion for a new trial and that is denied, you have 30 days from that date to file your first appeal, first level of appeal. Court will appoint a lawyer to represent you if you cannot afford one. I'll also advise you that you have 4 years from the date that your conviction becomes final in order to file a habeas corpus petition. Mr. Donnelly, can you tell me, are you all going to be involved in the next stage?
That remains to be seen, but my understanding is that we will remain on at the court's appointment until unless relieved by conflict counsel.
All right. And you'll make those arrangements.
We will communicate that with Mr. Ibarra and with the court.
Okay. All right. Anything else, Ms. Ross?
No, Your Honor.
Okay. It's going to take a little. Yeah. Can we take the?
We're going to move and then we can go down to the census.
Okay, that'll be fine. Can do that.
Everybody remain seated, please.
All right. That will conclude the proceedings.
Jose Antonio Ibarra looks like he will never see the light of day again. And so, like I ran down the guilty verdicts, let me run down the sentence. Count 1, malice murder, sentenced to life without the possibility of parole. Count 2, felony murder, vacated as a matter of law. Count 3, felony murder, vacated as a matter of law. Count 4, felony murder, vacated as a matter of law. Count 5, kidnapping with bodily injury, life in prison consecutive to count 1. Count 6, aggravated assault with intent to rape, 20 years consecutive to count 5. Count 7, aggravated battery, merging with count 1. Count 8, obstruction or hindering a person making an emergency phone call, 12 months consecutive to all the other time. Count 9, tampering with evidence, 12 months consecutive to all other time. And count 10, peeping Tom, 5 years consecutive to count 6. Bottom line, freedom, it's just going to be another buzzword to him when it's all said and done. By the time it's all said and done, no chance of parole. The guy is straight up and down done. Lakin Riley, justice has been served. Next up on the docket, a judge dismisses the Petito family's lawsuit against Moab police. I'm going to take you to my main man, 50 Grand, Vinny Politan, for an update on this in his segment, Something You Need to Know.
Time to reveal something else you need to know tonight. Let's take a look at the big board, and we've got Gabby Petito's parents. Their lawsuit has been tossed. The lawsuit against the Moab Police Department, who admittedly in the body cam video did not follow their own procedures when dealing with a domestic violence case. This is a case where a witness called it in that he was beating her. There's a photo. Yet they did not follow their own protocols, and now the lawsuit against Moab has been tossed. Let's take a look back at some of the back and forth between the Moab police and Gabby Petito.
Is there something on your cheek here? Looks like, did you get hit in the face? Kind of looks like something like hit you in the face. And then over on your arm, shoulder, right here. That's new, huh? Kind of a new mark?
Oh yeah, I don't know.
Can I see the other side of your face? So, what happened here and here?
I'm not sure. It was a... I was just trying to get in the back of the car and he accidentally on the back. And he got
So the backpack got you? So there's two people that came to us and told us that they saw him hit you. There's two people saying that they saw him punch you. We're just independent witnesses by Moonflower.
Well, to be honest, I definitely hit him first.
Where'd you hit him?
I slapped him in the face.
You slapped him first? And then what, just on his face?
He gets told me to shut up.
How many times did you slap him?
Romeo, India, Alpha.
Just a couple.
And then what? And then his reaction was to do what?
I slap him.
He just grabbed you?
Yeah.
Did he hit you though? I mean, it's okay if you're saying you hit him, and then I understand if he hit you, but we want to know the truth if he actually hit you. Because
I guess, yeah.
If you follow your procedures, she's alive, but that lawsuit has been tossed.
Yep, a judge ruled in favor of the Moab Police Department in a lawsuit brought by Gabby Petito's family. Gabby was murdered by her boyfriend Brian Laundrie in Wyoming in August of 2021. 2 weeks earlier, the couple was involved in a domestic violence incident, which Moab police failed to arrest one or both of them, contrary to state laws and department policy. Her family filed a $50 million lawsuit contending that the police did not investigate thoroughly enough to determine if Gabby was the victim of domestic violence and that her life was in danger. Judge Don Torgerson ruled that the Moab Police Department could not be held accountable due to the Government Immunity Act of Utah, which protects officers from liability. In doing so, he leaves the door open for the family to take the case to the Court of Appeals. I do not think that the plaintiffs made a prima facie case that Moab's officers' conduct here could have been the cause of death. Not necessarily the cause of death, but a cause of death, the judge said. And based on the pleadings and making every inference in favor of the plaintiffs, the court is going to deny the motion to dismiss on causation grounds because that's a factually intrusive question. Scripps News Salt Lake City reached out to the Petito family, who released the following statement. While the ruling today may feel like a setback, it was not unexpected. We never anticipated that this would be an easy process and look forward to the Utah Supreme Court holding up the Utah Constitution's original intent to preserve the right to recover the wrongful death claims under these circumstances. We remain committed to pursuing justice for Gabby and thank the many people who have continued to support us in that fight. Juju Bones is got to showing off a round of applause, and I gotta ask Juju Bones, is that for the Jose Ibarra verdict and sentencing? As far as the Gabby Petito case, the family filing that suit against Moab police, I believe deep down that this is far from over, and that they will keep this going, and they will find out, they will get the justice due for Gabby, even if it's monetary. And as for Brian Laundrie, well, he ended up taking his own life as well, so we'll just have to wait and see what becomes with that too. Honestly, I agree with Vinny though. If they had arrested either one or both of them would still be alive today. Next on the docket, ladies and gentlemen, is one I've waited for. Itch. I'm about to scratch it. This is the sentencing of as Court TV's Julie Grant calls her, Lion Leilani Simon. As you all know, Leilani Simon was accused and ultimately convicted of killing her son Quentin. His remains being found in a landfill. Now she gets to find out what her ultimate fate is. So what I'm going to do is here is, once again, I have the copyright notice up. I am going to mute. I'm going to take myself out of the shot and put up the full screen. The next voices you hear will be that. Oh, but before I do that, Moab, Juju Bones says she's still undecided if Moab police should be responsible. That's a tough call. Oh, but I do believe, had they done something, had they just arrested Gabby, just arrested Brian, or arrested both of them would be alive today. So here we go with Leilani Simon's sentencing. I'm going to mute. I'm going to take myself out of the shot and go full screen. The next voice you will hear will be covering this verdict will be Court TV anchor Michael Ayala.
TV Live, I'm Michael Ayala. We are tracking two big cases today here at Court TV. In Massachusetts, we are bringing you our newest trial, the jealous ex shot dead trial of Brian Camp. And in Georgia, it's sentencing day for Leilani Simon in the toddler in the landfill murder trial. Leilani Simon was convicted last month of killing her 20-month-old son Quentin, back in October of 2022. The toddler's body was found weeks later in a landfill. Well, today the judge listened to aggravating and mitigating evidence and testimony from Simon's family members. The judge is now issuing her sentence. So let's get you back inside that courtroom.
The one thing that I will say before pronouncing sentence is clearly little Quentin Simon's life and death impacted many, many individuals, but also the community at large. Leilani Marie Simon, the court sentences you as follows. Count 1, malice murder, felony, life with the possibility of parole. Count 2, felony murder, vacated by operation of law. Count 3, felony murder is vacated by operation of law. Count 4, concealing the death of another, 10 years consecutive to count 1. Count 5, false report of a crime is a misdemeanor, 12 months concurrent to count 4. Count 6, making a false statement, 5 years concurrent with count 4. Count 7, making a false statement, concurrent with count 4, 5 years. Count 8, false statement, 5 years consecutive with, concurrent with count 4. Count 9, making a false statement, 5 years concurrent with count 4. Count 10 merges into count 9. Count 11, 5 years concurrent with count 4. Count 12, making a false statement, 5 years concurrent with count 4. Delia, did I get count 11?
Yes, ma'am.
Okay, thank you. Count 13, making a false statement, 5 years concurrent with count 4. Count 14 merges into count 13. Count 15, 5 years concurrent with count 4. Count 16, making a false statement, 5 years concurrent with count 4. Count 17 merges into 16. Count 18, 5 years to serve concurrent with count 4. And false statements, making a false statement, count 19 concurrent with count 4. That is 5 years as well. Is there any issue that the state wants to point out with the sentence and the merger of the counts?
Was count 4, the 10 years to serve on count 4, was that consecutive to count 1?
It is consecutive to count 1.
And may I presume that the court is not imposing any fines?
No. Mr. Hilliard?
So just to make sure, life plus 10 is the operative sentence?
Life plus 10.
Life with pump. And I guess we should do the same for appeal as well. So.
And with that, Ms. Simon, you are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the court. And if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate appellate court of Georgia. If you cannot afford a lawyer, the court will appoint one for you. You are entitled to and will be given a transcript of all pre-trial, trial, and post-trial matters without cost to you if you cannot afford a transcript. You may file a motion for a new trial, or you may appeal your case directly to the appropriate appellate court of Georgia for review. I am signing the statement of appeal. I will hand this down to the clerk. If you'll please hand that to Mr. Hilliard.
With the assistance of counsel, Ms. Simon has acknowledged in writing her statement of appeal rights.
And the habeas statement is as follows. You're advised that the statute of limitations for habeas corpus in this state is 4 years in the case of felonies and 1 year in the case of misdemeanors. The statute begins to run from the date the conviction becomes final. All right. May there be peace somehow.
Nothing further from the defense, Judge.
Thank you very much.
Thank you.
Anything further?
No, Your Honor.
Nothing from the state, nothing from the defense.
No.
All right. This concludes this matter. We are adjourned.
All right, so not a lot of reaction from the defendant, Leilani Simon, after she is sentenced to essentially what's going to turn out to be 40 years before she's eligible for parole. And as we've said a number of times over the last few days, there is no guarantee at all that after that 40 years she will be granted parole. She will have the opportunity for parole. A lot will depend on how she functions in jail and how she acclimates herself and improves herself in jail. And perhaps, you know, some changes might be in order for this young lady.
And Juju Bones says she would have liked to have seen life without parole. Oh, well, let me break this down to you, Juju Bones. Let me break this down. And I even mentioned this to my pastor coming back from church today. Like you saw the crossbar, she must serve 40 years before she's eligible for parole. That is if Simon lives that long. I believe Leilani is in her early 20s. No, I take that back. Her mid-20s. If she lives long enough for this, she'll be in her mid-60s before she's even eligible for parole. And like in the Susan Smith case, just because you're eligible for parole doesn't necessarily mean you're going to be granted parole unless a lot of things happen. She would have to be honest with herself and with the people around her for what she did, and she has to show genuine remorse. And from the way she reacted leaving the courtroom after her sentence, I don't think that's gonna happen. But then again, that's not gonna happen right now. Who's to say that's gonna happen 40 years from now? Let's see. I don't like thinking she was given any hope after what she had done. I know that sounds horrible, but that's how I feel. I get that. Believe me, I get it. You harm a child. You harm a young child. If the death penalty don't get you, life in prison will. If she doesn't show any kind of remorse by the time her parole hearing comes up in 40 years, that's exactly where she will be. The same fate we can say for Susan Smith. She can step in front of a parole board every 2 years if she wants to. If she has no remorse for drowning her 3-year-old and her 14-month-old, Susan Smith will spend the rest of her natural life behind bars, only to see a parole board every 2 years until the day she passes on. Leilani Simon, if she has no remorse for what she did to little Quentin, if they have the same parole deadline as they do in South Carolina and Georgia, Leilani Simon will spend every 2 years until the day she passes on being denied by parole boards. A wise judge once said, "Don't do the crime if you can't do the time or pay the fine." Something to think about, right? Alright, next up. This one hits me in the heart. Now, let me give you a little pretext. I've been doing these live streams for a good few years now. I started out doing this as a politics stream, and then over the last 2.5, almost 3 years after that, I've been doing nothing but true crime, and I thank you guys for that too. But every summer, I take the time and I say, I give you this, and yes, this is a back scratcher. I say to you all not to leave your kids in a hot car. It's my annual summer PSA, not to leave kids in a hot car. But apparently some people just don't listen. And now we have a dad that's about to go on trial. And a plea offer. A trial date is set and a plea offer is in the works in the case of an Arizona dad charged with murder after leaving his 2-year-old daughter in a hot car this summer. Judge Kimberly Ortiz scheduled a trial for Christopher Schultz for September 15, 2025, which is set to last 10 days. The parties will be back in court for status hearings scheduled for January 27, 2025 and August 11, 2025. In court, prosecutors said they are in contact with Schultz's defense team and are working out the final details in a plea that will be offered, and will have that to the defense shortly. Schultz appeared in court with his attorney but did not speak. He was originally charged with second-degree murder for leaving his daughter asleep in the car in his driveway in July. A month later, a grand jury indicted him on charges of first-degree murder and child abuse. Schultz pleaded not guilty to the charges. During the investigation, Schultz had told police he left his daughter in the car with the air conditioning on because she'd been sleeping, something he revealed he had done before. On the day she died, the car and the air conditioning had shut off after Schultz went into the house. Let's see, Juju Bones is calling in a night. All right, Juju Bones. I still have a little bit more show left, so you can make yourself as part of the replay gang at the very end of this thing, okay? Hey, but thanks for coming on. I appreciate the commentary. As for this Schultz hot car case, it's really a matter of common sense, which for some parents is all too uncommon. All you have to do is use your common sense in that you do not leave your child in a hot car, especially in Arizona, in your driveway. I don't care if you have air conditioning and the car on. You have those vehicles that automatically shut off. Pay attention. Your children's lives depend on it. Whew. Next, the Illinois Supreme Court overturned Jesse Smollett's conviction that he staged a racist and homophobic attack on himself in 2019. Okay, this was breaking news earlier in the week. So again, the copyright is up. I'm going to mute. I'm going to take myself out the shot, and I'm going to take you to breaking news from Court TV. Your front row seat to justice.
And we do have some breaking news this into our Court TV newsroom. Jussie Smollett's conviction on allegations that he staged a racist and homophobic attack on himself back in 2019 and for lying to police has been overturned by the Illinois Supreme Court. The former Empire actor was convicted on 5 counts of disorderly conduct and sentenced to 150 days in jail, but was released after serving only 6 days while he appealed his case. Defense attorneys argued his trial violated his Fifth Amendment protections against double jeopardy after a special prosecutor brought a new indictment against him. This came after the state attorney had agreed to drop the original charges against him. Today, Illinois' highest court sided with Smollett and reversed his conviction, ordering the case to be dismissed against him. Smollett had claimed 2 men assaulted him, yelled racial and homophobic slurs, and tossed a noose around his neck, leading to a search for the suspects in Chicago and causing national uproar.
Also of note, let me look up the name real quick. Okay, Chicago officials can still pursue their civil case against Smollett that seeks to recoup up the $130,000, the amount police say they paid in overtime to pursue Smollett's accusations. Illinois Supreme Court Chief Justice Mary Jane Theis and Justice Joy Cunningham took no part in that decision. Well, I guess there's still more left to. A little more meat left on that bone, and we'll see what happens if the civil case takes place, and we'll see what becomes of that as well. Next up, former Sheriff Steins is indicted for the murder of a Kentucky judge. Sean Mickey Steins indicted on a charge of murder of a public official for allegedly killing District Judge Kevin Mullins. All right. And we go to more coverage from Court TV.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today bringing you your front row seat to justice. Now, we begin this hour with breaking news. A former Kentucky sheriff charged with the shooting and killing of a district judge in the judge's own courthouse chambers has been indicted.
Former Lecter County Sheriff Sean Mickey Steins is accused of shooting
Lecter County District Judge Kevin multiple times. Now, he died at the scene. The fatal shooting sent shockwaves to the small Appalachian town and the nation.
Steins' arraignment is set for Monday. Of course, Court TV will be there to cover it all. And you and I were just talking about that. It's a formality. We know, based on video they already released, that he did shoot the judge.
Yeah, it was a formality. They showed the evidence to a grand jury. He got indicted. There was no question that would happen because the act is on video.
Yes.
And the question is there some justification for it? I guess.
Right.
At this point, we do not know.
But you still go through all the different steps unless you waive them appropriately, etc. So this is the process that will be followed.
arraignment will take place on Monday. At a probable cause hearing in October, prosecutors showed a silent video that appeared to show Steins walking into the judge's chambers with a weapon and firing multiple times at the victim, who frantically tried to escape under his desk. Steins, who was sheriff at the time of the shooting, resigned on October 1st, hours before appearing in court to plead not guilty to murder charges. Investigators have not offered any potential motive for the murder, and those who knew Steins and Mullins said that the two had worked together for years and were friends. To date, prosecutors have not announced whether they will seek the death penalty. So when the indictment goes down, Bethea'S Byte Reloaded will be watching it, and I will have that coverage here. Next, we have a report on the Baby Madison cold case. Authorities believe Baby Madison had been left along the stretch of highway in Texas for 3 to 5 months before being found. So we're going to take you now to coverage in that case with the Honorable Judge Ashley Wilcott, Court TV.
We are learning new details in a cold case. In September of 2016, the remains of a young girl believed to be between the ages of 2 and 5 years old were found in a suitcase along a Texas interstate. Authorities have been working to identify the girl, and today, during a press conference, they shared a photo of the dress she was wearing and a new photo of what they believe the little girl may have looked like, and they asked for the public's help in identifying her.
On September 17, 2016, an abandoned suitcase was discovered at the edge of a pasture off of I-45, just north of Madisonville, Texas. Upon further inspection, skeletal remains were discovered inside a white garbage bag that was stowed inside that suitcase. Throughout the investigation, we've learned that the remains were of a girl just 2 to 5 years of age. She had long, thick, dark hair just past her shoulders. Her genetic makeup advised that she had ancestral ties to El Salvador as well as Nuevo Leon, Mexico. She wore this dress of the Mon Petit brand, sized 4T. This pink dress said "Follow Your Dreams" and it has butterflies on it. She wore a size 4 diaper and she had a feeding tube. So we know that at some point in time in her very short life, she required medical attention. This little girl, who we've come to know as Baby Madison, is still to this day unidentified. Today, we are also asking for the public's help. Have you seen this child? Think back to the summer of 2016, maybe even before. Have you seen a little girl wearing a pink butterfly dress? Did she have a feeding tube? Did she have long dark hair just past her little shoulders? I believe that someone out there knows something. And if you have any information about her or who disposed of her remains, please call me at the Madison County Sheriff's Office here in Madisonville, Texas. That number is 936-348-2755. My direct extension is 322. Thank you again all for taking your time and being here today. Thank you to the Texas Rangers, Ranger Cash, and the FBI for all their assistance over the years. I truly believe that together we're going to solve Baby Madison's case.
Just heartbreaking. Again, if you have any information regarding Baby Madison, please call the Madison County Sheriff's Office at 936-348-2755, extension 322.
This case has baffled so many people in Texas. And this could not be
And the FBI.
There we go. This could not be understated enough. So I'm gonna go ahead and put my stamp on it. If there's anybody out there in that Madisonville, Texas area that has any information on or as to the identity of baby Madison, please give the Madison County Sheriff's Office a call at immediately. That number on your screen is 936-348-2755, extension 322, or you can also call the National Center for Missing and Exploited Children's 24-hour line. That number is 1-800-THE-LOST, 1-800-843-5678. But whatever you do, like I always say for cases like this, if you see something, please say something. That way, we can do something. Let's identify baby Madison, and then let's get justice for baby Madison. Next on the docket, actor Jonathan Majors. He and his ex-girlfriend drops the assault and defamation suit after reaching a settlement agreement. Jonathan Majors' ex-girlfriend has dropped her assault and defamation lawsuit against the once rising Hollywood star after reaching a settlement. Lawyers for Majors and Grace Jabari agreed to dismiss the case with prejudice, according to a joint filing in Manhattan federal court. Jabari's lawyers said that the suit was favorably settled but declined to elaborate. Grace Jabari has exhibited tremendous courage throughout this very long and difficult process, attorney Brittany Henderson said in a statement. We hope that she can finally put this chapter behind her and move forward with her head held high. Representatives for Majors didn't respond to emails seeking comment. Jabari, in her lawsuit filed in March, accused the 35-year-old Marvel and Creed 3 star of subjecting her to escalating incidents of physical and verbal abuse during their relationship, including assault, battery, defamation, and infliction of emotional distress. The British dancer filed the suit months after Majors was convicted of misdemeanor assault and harassment in connection with an altercation in Manhattan. During a fight that began in the backseat of a chauffeured car before spilling out into the streets, Jabari said Majors hit her head with his open hand, twisted her arm behind her back, and squeezed her middle finger until it fractured. Majors claimed Jabari had flown into a jealous rage and was the aggressor, and that he was only trying to regain his phone and get away safely. Majors avoided jail time but was ordered by a judge in April to complete a year-long counseling program. Following the guilty verdict, Majors was immediately dropped by Marvel Studios, which had cast him as Kang the Conqueror, a role envisioned as the main villain in the entertainment empire's movies and television shows for years to come. Majors and Jabari had met in 2021 on the set of Marvel's Ant-Man and the Wasp: Quantumania, in which Majors played Kang and Jabari served as a movement coach. Majors has slowly re-emerged on the Hollywood scene in recent weeks. His long-shelved film Magazine Dreams was acquired for theatrical release last month. The bodybuilder drama had garnered early Oscar buzz for Majors, but was dropped by its distributors following his conviction last December. Then, earlier this month, Majors and fellow actor Megan Good announced their engagement at the Ebony Power 100 Gala in Los Angeles. So this is good news for both Grace Jabari and Jonathan Majors. Let's see what happens to these two from here. And now it's time once again for another edition of Did He Do It? Next up, Diddy's lawyers accuse prosecutors of altering hotel video in a bid for pre-trial release. They're saying the prosecutors are arguing that Combs should remain in Brooklyn's Metropolitan Detention Center while he awaits trial. Diddy was due back in court for his third attempt to convince a judge in his federal sex trafficking case that he deserves bail. Federal prosecutors argue Combs should remain in Brooklyn's Metropolitan Detention Center while he awaits trial, arguing he's a threat to potential witnesses and accusers. Combs' lawyers accuse prosecutors of exaggerating and spinning evidence to support unsubstantiated allegations that Combs is tampering with witnesses. Combs pleaded not guilty in September to charges of racketeering, sex trafficking, and interstate transportation to engage in prostitution. He is accused of using his star power and the resources of his business empire to coerce women into participating in drug-fueled orgies with male sex workers known as freak-offs. 2 other judges ordered Combs held without bail after his arrest in September, based on prosecutors' claims that he was in constant contact with a grand jury witness and an alleged victim before his arrest. Since his arrest, prosecutors allege Combs has continued contacting witnesses and alleged victims from jail through third parties using subversive and unauthorized means, including other inmates' phone accounts, third-party messaging apps, and three-way calls. Prosecutors tried to rely on evidence from notes in Combs' cell, which allegedly mentioned efforts to get dirt on witnesses and alleged victims. Judge Aaron Subramanian blocked their efforts in a last-minute hearing because of concerns about potential violations of attorney-client privilege. As evidence of Combs' alleged dangerousness, prosecutors cite the infamous video that allegedly showed Combs chasing and beating longtime girlfriend Cassie Ventura in a hotel hallway in 2016. But Combs' lawyers say new revelations gleaned from the exchange of evidence suggest prosecutors altered the video and edited it to make a toxic lovers' quarrel look like a domestic violence incident. In a motion filed Combs' defense said they have a forensic video analyst on standby to testify about the alleged alterations. We'll see what the fallout is from that. So tune in next time for another edition of Did He Do It? And let's see what I got next on the docket. Oh, before I go on to my last thing on the docket, I have to drop back real quick for another sentencing. Apparently I forgot to put this one on my docket. This is the sentencing of Spencer Ross Pearson, who was accused of the attempted murders of both his ex-girlfriend and her mother.
He does require some specialized treatment for a mental disorder that is unrelated to substance abuse or addiction or for physical disability, and the defendant is amenable to treatment. I don't know that I agree that this was an unsophisticated manner. I'm not going to find that as to that factor. And I do believe that the defendant is old enough to appreciate the consequences of the offense. So the only factor that the court does find that the defense has met is the fact that he does require some specialized treatment for a mental disorder that is unrelated to substance abuse or addiction or for physical disability. That does not, the analysis of downward departure does not stop at the defense's meeting the threshold and establishing by preponderance of the evidence that there are mitigating circumstances that would permit this court to deviate below that guideline sentence. The second prong of that analysis is whether or not the court should. June 3rd of 2023, the events that unfolded on that afternoon were horrific. This defendant launched a vicious attack on a 17-year-old girl who had done nothing but show him love. And only weeks earlier had done her part to try to save his life when he attempted suicide. The same person that tried to save his life, he violently and viciously attacked. Many folks in this courtroom have declared Kennedy Armstrong a hero. This court has no quarrel with that assessment. Kennedy Armstrong is most certainly a hero. And but for his actions and the actions of Madison's mother, this defendant would have successfully killed Madison Chimmons. That crime, the crime that was described and shown here today, and the result of that crime, and the impact of this crime that it has had on all three of the victims in this case, leads this court to the conclusion that any deviation below the guidelines is inappropriate. So I'm declining and denying the defendant's motion for downward departure. I have considered the mitigating circumstances that have been well presented by the defense in this case. Mr. Kuchergis, you have done an excellent job in representing your client and providing this court with mitigation. And this court has carefully thought and weighed and considered your client's age, his lack of any prior criminal history, the fact that he was suffering from a depressive, clearly a depressive state of mind when this happened, his age. This court does not impose a sentence based on vengeance, as was mentioned, that courts are not here to sentence out of vengeance. This court has carefully thought about all of the mitigation in this case. But the crime that was committed the impact that this crime has had on Madison, Jacqueline, and Kennedy it just far outweighs any of the mitigation that this court has considered. There are just certain crimes that are committed that merit the maximum possible sentence. And this court finds that this is one of them. Spencer Pearson, you have entered a plea of guilty to 2 counts of attempted first-degree murder with a weapon. As to counts 1 and 3 of the information, you are adjudicated guilty. You are sentenced to serve the remainder of your life in prison. As to count 5, you are adjudicated guilty. You are sentenced to serve 30 years in Florida State Prison. All sentences are to run concurrent with each other. Madam Clerk, please reflect that he is 536 days that he has previously served and imposed the standard felony court costs. Mr. Pearson, you have 30 days to appeal the legality of this court sentence. If you wish to appeal but cannot afford an attorney, one will be appointed for you. This court is adjourned.
Your Honor, I believe the state has an announcement.
Yes. As to the remaining counts.
State would announce on all projects.
Mr. Pearson.
Come on, approach.
Yeah.
And there you have it, ladies and gentlemen. Spencer Ross Pearson, found guilty on attempted murder charges, has been sentenced to life in prison without the possibility of parole. He had originally faced 18 years to life, and his attorneys argued for a sentence below 18 years. But Judge Lee R. Smith announced that any deviation below the guidelines is inappropriate. 20-year-old Pearson was arrested in June 2023 for stabbing Madison Schmitz and her mother, Jacqueline Roche, outside a Ponte Vedra Beach restaurant. Schmitz was 17 at the time and was temporarily paralyzed after being stabbed more than a dozen times. Pearson had been harassing his ex-girlfriend for months, according to the arrest warrant. The attack happened as the mother and daughter were trying to leave the restaurant after spotting Pearson. Kennedy Armstrong, a bystander, was injured in the attack while trying to help Schmitz. A warrant stated Pearson also sliced his own throat several times, telling witnesses he was attempting to kill himself. In July, Pearson pleaded guilty to 2 counts of attempted first-degree murder and 1 count of aggravated battery causing serious bodily injury. The courtroom was packed at Pearson's sentencing hearing, with the victims sitting side by side in the front row, surrounded by family and friends. Following those proceedings, prosecutors in the sheriff's office held a press conference where the Carnegie Medal was presented to both Roche and Armstrong. That's another case of guilty as charged. Finally, we wrap this edition up with the sentencing of Tiffany Lucas. Tiffany Lucas. She had pled guilty to killing her 2 young sons. Now we go to court TV to see what her fate is.
Court will call the case of Commonwealth versus Tiffany Lucas. There have been references made by the defense to the defendant's association with God while she was acting. This is not a question of violation of the laws of God or any religious belief. This is a question of violations of the laws of this Commonwealth, particularly statutory murder, which provides for a violation when someone with the intent to cause the death of another person causes the death of that person. Ms. Lucas, to her credit, has come before the court and has admitted to her conduct. She has entered a plea of guilty to 2 counts of murder that involves the intentional taking of a life. Now, the court has considered mitigating conditions and aggravating circumstances as argued by the parties. The court has considered the contents of the file as well as recent filings that detail the defendant's position. The court will note that the defendant's act of killing were intentional and resulted in multiple deaths, in particular 2 children under 12 years of age. The law of this Commonwealth is clear. The statutory penalty for each of these counts is 20 to 50 years or life in prison. Mr. Donnelly has testified as to parole eligibility. Now, what I will say is this. Kentucky's method of incarceration for felony offenses is what's referred to as indeterminate sentencing. It can be somewhat difficult to follow if you don't deal with it every day. But ultimately, the court has to assume that the components of the judicial system, which includes the executive branch's parole board, will be followed to the law. So the duties and responsibilities of that board and what they do are to be determined by that board. This court has to assume they will do what is just and appropriate. What I have struggled with through this hearing today is a mother is more than the giving of life. It is providing food, clothing, shelter, but more importantly, love and security. I cannot imagine the sheer horror these children must have experienced seeing their mother with a gun. The sheer horror the second child had as he heard the discharge of that weapon for the first child. And maybe even both of them seeing their mother pull the trigger, taking their life. At this time, the court will state for the record, the court has considered the probation pre-sentence report, arguments of counsel, the contents of the file, and no sufficient reason having been shown why judgment not be pronounced and sentence imposed. Case number 23 CR 404, Commonwealth of Kentucky versus Tiffany Lucas, as to count 1. The court will adjudge the defendant guilty of the offense of murder and fix her sentence at life in prison. On count 2, the court will adjudge the defendant guilty of the offense of murder and fix her sentence at life in prison. This time, the court will order that the Sheriff's Department deliver the defendant to the custody of the Corrections Cabinet for service of her sentence of imprisonment. That's all for today. Court will be adjourned.
And a round of applause ends that hearing and begins Tiffany Lucas's sentence to not one but 2 life sentences behind bars. One for 6-year-old Maurice Baker Jr. and one for 9-year-old Jaden Howard. Both of those boys she shot to death inside the family's home on November 8, 2023. Regina Rowland, Jaden's grandmother, was the first family member to address the court at the sentencing, and she didn't hold back as she demanded justice for the children. "I want you to suffer just like I'm suffering now," she said. You have ripped our lives apart, and you know that you could have gave them kids to us and we would have took care of them, but you have been selfish. My heart is in pieces. And who could blame that grandmother? Who could blame her at all? So to recap, Chloe Driver, guilty but mentally ill. Sentencing will take place December 12th. Susan Smith, parole hearing after 30 years behind bars. Parole denied. Jose Ibarra, guilty of 10 counts involving the death of Laken Riley. Sentenced to life in prison without parole. Leilani Simon, guilty in the murder of Quentin Simon. Sentenced to life in prison. She has to serve 40 years before she's eligible for parole. Spencer Ross Pearson, guilty of the attempted murders of his ex-girlfriend and her mother. Both he'll spend the rest of his life in prison. Tiffany Lucas, pleading guilty to the murder of both of her sons. Sentenced to 2 life terms in prison. All of them made the choice to commit these crimes. All of them took the risk in court. And all of them are guilty as charged. Thank you so much for joining me on this edition of Bethea'S Byte Reloaded. If you want to help your boy out, and if you enjoyed everything you saw here tonight, you can also always make sure to like, share, subscribe, comment, and this is the free way to support the channel. If you want to tip me, here's all the cash links here. Here, you can hit me up at PayPal me, EKB316, on Cash App at $ EKB316, or Venmo at EB the Last Outlaw. Nothing obligated, but it's always appreciated. And if you just want to get in contact with me, I'm all over social media. I'm on Facebook at Bethea'S Byte Reloaded. On X at EKB316, all caps. I'm here on YouTube at Bethea'S Byte Reloaded. On Instagram, EKB316, all lowercase. On TikTok, at King of Hearts 316 2021. And you can email me. The address is kingofhearts316_09 at outlook.com. Alright, guys. As before we get out of here, here it is one more time. Before Thanksgiving, this is your home for true crime news without all the drama, where your opinions matter, where lively debates are encouraged, where your voice is heard, and above all else, it's justice served. Don't believe me on that last part? Ask all of our defendants: Chloe Driver, Susan Smith, Jose Ibarra, Lion Leilani Simon, Spencer Ross Pearson, and Tiffany Lucas. Remember where you are, ladies and gentlemen. This is Bethea'S Byte. And it's reloaded. Thank you all so much for joining me here tonight. I want to wish you all a wonderful Thanksgiving holiday. I hope to be back with you again soon. Don't get stuffed too much. Enjoy all the football you want. Enjoy your time with your family. And we'll do this again sometime soon. Until next time, you all know what to do from here. Bite.
Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe to the channel, and drop me a comment on this video. Also, be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.